European Court of Human Rights is now in session, hearing a case of Iran versus the Republic of America. And the applicant is invited to submit.
Good morning, Madam President, Your Excellencies, esteemed opponents, may it please the court. My name is Volodymyr Saratov, and I appear as agent for the applicant in the case Iran versus the Republic of Nereria. My co-agents are Mr. Dmitro Soldatenko and Mr. Anton Makhno. Today, I will be speaking for 12 minutes, and my co-agents will be speaking for 11 and 12 minutes respectively. I will argue the violation of Article 5 of the European Convention on Human Rights. My co-agent, Mr. Soldatenko, will argue the violation of Article 6, and Mr. Makhno will argue the violation of Article 3 of the Convention. I will be making two submissions to the court. Firstly, there was no reasonable suspicion of Mr. Tiron having aided or instigated terroristic attacks on the 27th of December 2018. And as a second submission, I will argue that the detention itself was unlawful. The main purpose of Article 5 of the European Convention on Human Rights is to prevent arbitrary deprivation of liberty. If there weren't Article 5 that protects personal liberty, then the whole system of human rights has no application. In other words, how can one talk about any other rights under the risk of arbitrary deprivation of liberty? That is why the exemptions embodied in Article 5 shall be interpreted in strict manner and with the presumptions of innocence. Article 5.1c can be divided in two limbs. The first one refers to the lawful arrest based on reasonable suspicion of persons having committed an offense. Thus, this limb refers to the offenses that are already committed. The second limb is formulated when it is reasonably considered necessary to prevent persons committing an offense. As this court found in the case Ilnher versus Germany, under prevention policy, it is afforded for the states to prevent sufficiently concrete and specific offenses as regards, in particular, when it is known the place and the details of the offense, and when some victims are known prior to the offense. In the present case, the attempt of terroristic attack took place on the 27th of December, and as becomes evident from the facts of the case, the police didn't know about the offense to be committed. Afterwards, on the 28th of December, all suspected Hungarian nationals, including Mr. Tiron, were detained. This means that the detention of the persons had happened after the alleged offense, and this means that in the present case, the applicant would argue the first limb of Article 5.1c, namely reasonable suspicion of having committed an offense.
Counsel, how would you rebut the argument that Mr. Tyron had the allegiance with the terrorist organization Taneva Zuchiens? So could you then argue that based on his links with the terrorist organization, there existed reasonable suspicion that he indeed instigated or aided this crime?
Your Excellency, the applicant would refer to paragraph 14 of the present case, where it is provided that only Zucha's executive board members were the members of Teniba, unlike Mr. Tiron, who was an ordinary member responsible for conducting prayers for recruited newcomers. Turning back to the reasonable suspicion, it was found by the court that reasonable suspicion presupposes the existence of facts or information that would satisfy an objective observer that the person concerned may have committed an offense. In terms of dealing with terroristic crimes, the court has found that dealing with terrorism cannot justify stretching the notion of Article 5, whereas the safeguards secured by Article 5
of course, Counsel, but usually state security forces may have some secret information, and the state may not be sometimes in a position to reveal all the information for security reasons. Would you then submit that for example, in combating such crimes as terrorism, it would be justified, for example, under Article 15, to take certain measures derogating from Article 5 of the Convention?
Your Excellency, the applicant would raise 2 points. Firstly, in the present case, it is not provided that the narrator referred to Article 15, namely the state of national emergency. And the applicant would also recall the judgment of Fox, Campbell and Hartley versus the UK, where the government relied solely on the confidential sources and refused to disclose them to the court. And the court has found that it is not allowed for the state to rely solely on confidential sources. Therefore, there must exist some factual background to justify.
How would you then suggest to balance the state security interests and human rights protection interests? How can you do the state is still obliged to protect security of everyone?
Your Excellency, as becomes evident from the court's jurisprudence, in particular the cases which deal with terrorism, to find reasonable suspicion, there must be enough evidence which includes the confidential sources for the government and the factual background concerning the person accused. In the present case, the only factual background we can find is that Mr. Tiron had been member of Zuchan's organization for 3 months. However, he was an ordinary member of the group, and according to the present case, only Zuchan's executive board members were associated with Teniba, the organization which tried to commit an offense. Thus, it is not possible in the present case to provide a real link between Mr. Tiron and organization named Teniba, since the ordinary members of these 2 groups are not connected. Additionally, applicant would argue the absence of questioning of Mr. Tiron during the detention. The purpose of questioning during the detention under Article 5.1c of the Convention is to further the criminal investigation by confirming or dispelling the concrete suspicion. In the present case, Mr. Tiron was detained and he was not questioned during his detention.
Sorry to interrupt you, Counsel. How many persons were detained at that stage? Do you know that?
No, Your Excellency, the case is silent on that matter. But as it is provided,
And if it were many, and as far as I got from facts of the case, I got the idea that there were many persons detained. So maybe it was just a question of timing the interrogation. Wouldn't that make it very hard for the state to question all of them at the same time? I think that there were many of citizens from the same state as your replicant.
yes, Your Excellency, but as maybe...
That's liver the obligation of the state.
Yes, Your Excellency, the applicant would agree to your argument, but on the contrary, as it was found in many cases where deal with terrorism, it is quite similar in that cases that the people who were detained, they were further questioned by the authorities in order to confirm or dispel the charges. But in the present case, there was no such questioning. And the fact that the Iranian police suspected all suspected Hungarian nationals can raise the issue of indiscriminatory and arbitrary deprivation of liberty of all suspected Hungarian nationals without further purpose of investigation of the offense. Consequently, the applicant submits under the first submission that their threshold for reasonable suspicion of Mr. Tiron having aided or instigated terroristic attacks is not reached because of the absence of real link between Mr. Tiron and organization named Teniba.
Counsel, let me ask you one more question concerning reasonable suspicion. For the reasonable observer, the standard that you suggest, taking into account paragraph 12 and paragraph 18 of the case study, where it is stated that he had occasional communications with the executive board, Zuchan's executive board, as well as he frequently used like, share, and pin button to endorse posts raising awareness about dubious deaths of Zuchi Tolontos. Wouldn't you suggest, or wouldn't a reasonable observer infer from these facts that he has some sort of connection to this terrorist organization then?
Your Excellency, there is no real link between, because this fact show the little evidence since the mere communication and some mere contacts, they cannot justify the objective observer in the present case. Moving to the second argument, applicant would argue that Mr. Tiron's detention on the 28th of December is unlawful. The same provision of the Convention, namely Article 5.1c, provides that the detention of a person is lawful when it is reasonably considered necessary to prevent persons fleeing after the alleged offense committed. With particular regard to the risk of fleeing, consideration must be given to the character of the person involved and, among other, links with the state. Moreover, as the court has found in the case Buzaji versus the Republic of Moldova, when the only remaining reason for detention is the fear that the person might flee after the alleged offense committed, then the person shall be released if there is possible to obtain guarantees that would secure persons appearing before the authorities. Considering the personality of Mr. Tiron, he is an asylum seeker who was placed into detention center upon his arrival in the area where he claimed a refugee status. As the state practice shows, these centers are fenced and guarded places where the freedom of movement is limited and the authorities could easily reach a person. This means that there was no real need to transfer Mr. Tiron from detention center to another asylum seekers detention center, providing the fact that in the second one, the conditions of the detention were much worse. And additionally, the applicant would argue that Mr. Tiron had applied for the status of refugee. He had many interviews with Immigration Service of Nigeria and appealed his decision to the courts of Nigeria on many occasions. This shows that Mr. Tiron had true desire to stay in Nigeria and had no desire to flee from that state.
Counsel, was there any guarantee for the state, considering the application for asylum, that he would in fact not disappear if he was left in the detention center for migrants, from where there is still liberty to move?
Your Excellency, as the state practice shows, in those centers the freedom of movement is limited, and the person cannot arbitrate.
It's not totally.
Yes, Your Excellency, but if the person would go from that center, that would breach the law of the state, that would constitute the unlawful entry in that state, and these people, the asylum seekers, are only allowed to stay in those centers during the refugee procedure. And additionally, the applicant would argue that Mr. Tiron could not return back to Hungary since he was receiving threatening letters from rebels while being in the area.
So, if I understand correctly, you really hope that if Mr. Tiron had left from the refugee detention center, he would have sort of lost his status of asylum seeker?
Not exactly, Your Excellency. The applicant argued that there was no need to put Mr. Tiron in detention center since he was prior put in asylum seekers. Since he was put prior in detention center where the asylum seekers are held, and he must have stayed there because in detention center where he was put lately, the conditions much worse.
But if he had left the asylum seekers detention center, do you think that would have deteriorated his status as an asylum applicant in Malawi? Is there any provision in your country that leaving from the detention center for applicants would make it harder for the applicant to bring through his claim? Is there any legislation like that in your country?
No, Your Excellency.
You talked about that would amount to illegally having entered the country. That does not really fit into what the Geneva Convention is providing for asylum seekers.
Your Excellency, the case is silent on that matter, but as the state practice shows, asylum seekers are not allowed to leave these centers where they are held.
In your state?
The case is silent on that matter, Your Excellency, so the applicant would generally apply the state practice. Thus, under the second argument, the applicant submits that their detention itself of Mr. Tiron was unlawful. This concludes my arguments. If I can be of no further assistance to this court, I'll give the floor to my co-agent, Mr. Soldatenko. May it please the court.
Good morning, Madam President, Your Excellencies, esteemed opponents. May it please the court. My name is Moot Soldatenko, and I appear on behalf of Mr. Nasul Tiron, the applicant in the present proceedings. In next 11 minutes, I will be arguing that Nararia has violated Article 6 of the Convention. Your Excellencies, this case involves Mr. Nasul Tiron's right for a fair trial, the right which has been disrupted brazenly during his stay in Nararia. He filed an application for an international protection, which was reviewed by the Immigration Service of Nararia, then appealed to the Immigration Court of Nararia, and finally dismissed. And the question before this honorable court is whether those proceedings were fair. As such,
excuse me, before you proceed with the analysis of Article 6, specific criteria of Article 6, could you first illustrate for this court why is Article 6 in the first place applicable in these circumstances? Does asylum procedure, these judgments that were delivered by domestic courts, fall into the civil rights and obligations category in your submission?
Your Excellency, this question leads me to the first argument of the applicant. We submit that Article 6 applies to the present situation because the absence of protection will create the gap in the protection of the human rights. Applicant, respondent may refer plenty of cases of this honorable court where it rejected to apply Article 6 to the refugees. However, the reasoning of the court was that refugees are protected by the right to a fair trial, but not under Article 6 of the Convention, but under the Protocol 7 of the Convention. And it was mentioned by many judges in their decent opinions. For example, Judge Albuquerque in the Souza Ribeiro case, Judge Albuquerque in Hirshiyama case, and also Judge Ress in Ferranzi versus Italy. And according to the explanatory report to the Protocol 7, Article 1 applies only to the documented refugees and those whose status is recognized by the host state. And the persons as Mr. Nasrul Tiran, undocumented migrants and refugees, are not protected by Protocol 7. And because of the self-created gap of this honorable court, which was mentioned by the Judge Albuquerque in his decent opinion, refugees are not protected by Article 6 neither. And this is
provided that we agree that we imagine that Article 6 is not applicable, and then we agree with the. Is there any other legal remedy under the Convention?
Your Excellency, we also will claim in conjunction with Article 6 the absence of the effective remedy, because in fact migrants like Mr. Nasrul Tiran, they are not protected nor by Protocol 7, nor by Article 6, nor by the Refugee Convention, which only grants the procedural guarantees in respect of the...
There's still any legal provision in the very convention based on which this court works?
Your Excellency, we only refer the Article 6 and Article 613, the right to effective remedy.
Yes, but you know that Article 13 has to be read in conjunction with another article of the Convention. If you say Article 6 would not apply, to which Convention provision would you combine Article 13?
Your
It's an
Excellency,
accessory right.
Your Excellency.
It's not a right on its own basis.
Your Excellency, if Mr. Nasrul Tiran will be facing expulsion proceedings, we will be arguing Article 13 in conjunction with Article 3 of the Convention. And we also want to draw the attention of the court to the relevant international practice, because this question was assessed by the Inter-American Court of the Human Rights, and in its advisory opinion on the undocumented refugee, the Inter-American Court of Human Rights stated that the right of the due process of law is a minimum guarantee for all the persons, documented and undocumented, and this right applies to them rationa materi and rationa persona without any discrimination between nationals and non-nationals of the state. If the court has no further questions on the applicability of Article 6, I will proceed with the substantive part of my argument.
Just one more question. The Inter-American Convention on Human Rights, do they have a right to asylum in their convention?
Your Excellency, of course. And this is an issue in the Latin America, and the court, yes.
Does our court, in the legal basis we have to apply, do we have a right to asylum?
Your Excellency, in the ECHR we do not have the right to asylum. However, the court has referred to the practice of the Inter-American Court of Human Rights. For example, in Kurt versus Turkey, the Grand Chamber referred to the case Velasquez-Rodriguez versus Honduras. And thus we ask this court to assess the relevant international practice. Turning to the second argument.
Counsel, excuse me, before you turn to the second argument, do you realize that this is not the court of fourth instance? And that whether Mr. Tyrone can be referred to his country of origin can also be adjudicated under Article 3. So why is then necessary to also adjudicate on a separate violation, Article 6?
Your Excellency, Article 6 does not, we do not argue the substantive part, the decision of the immigration court. We only argue the procedure which was unfairly impaired, and the procedural guarantees which were granted to Mr. Nasrullah.
Why was the procedure unfairly impaired?
Your Excellency, the procedure must be assessed as a whole, and we raised two grounds. First is improper administration of evidence, and the second is the insufficient reasoning of the immigration court. Turning to the first point, it was decided in the Blucher versus Czech Republic case that the evidence must be presented in the court in such way to guarantee a fair trial. And this honorable court may also draw inspiration from the cases in the criminal link. For example, in RS versus Germany, the court assessed the disciplinary proceedings against the soldier who smoked marijuana when he was on duty, and he was facing the disciplinary proceedings, and the court has reviewed this case under the civil link. However, it also took into account the right of prohibition of self-incrimination, and this is the issue in the present case, because Mr. Nasrul Turan was interviewed by the asylum officer during the first interview in the immigration service of Nareya without a lawyer. And this is the ground to state that this impaired the fairness of the proceedings, since in Panovitz versus Cyprus, this honorable court has established that absence of a lawyer during the first interview on the pretrial stage impairs the fairness of the proceedings. This fact must be assessed in conjunction with insufficient reasoning of the immigration court. According to the paragraph 17 of the present case, Mr. Nasrul Turan has submitted an additional argument that he cannot be protected by the temporary government of Halgavi because he is former member of a rebellion group named Zuchans. And as it was decided by this honorable court in H versus Belgium, the court has to give the sufficient ground. And in Hirabalani, the court specified this provision stating that if the argument is decisive for the outcome of the case, the court must give specific and express reply. And also in Helle versus Finland, this court has found the violation of Article 6, where the court has adhered to the decision of the pretrial stage body without giving any further argumentation. And this is the situation in the present case, because according to the paragraph 17, the Immigration Court of Neraria simply adhered to the decision of the Immigration Service of Neraria and give no further argumentation why this should be rejected. Thus, applicant asks this honorable court to adjudge and declare that Article 6 is applicable to the asylum proceedings, and it is the time to change its practice, because the convention is a living instrument, as was decided in the Tyre versus the UK. And secondly, that Neraria has violated Article 6 of the convention and failed to ensure a fair hearing in the case of Mr. Nasultiron. May it please the court.
Agent, I would have a question regarding what you have submitted, that Mr. Taran announced the threat, forthcoming threat upon returning to Neraria, to Halgavi. How timely was that announcement from the side of Mr. Tiron?
Your Excellency, Mr. Tiron has submitted that as soon as he got a lawyer, which give him the opinion how to behave. Because on the initial stage, Mr. Nasultiron was in a bad moral condition. He just fled from his country of origin, and he did not know how to behave. And as soon as he got the legal support, he submitted it to the Immigration Service of Neraria. And moreover, what is at stake is whether the Immigration Court took all the arguments into account.
Yes, what I'm asking is whether Mr. Tiron had possibility to state his concerns regarding the upcoming threats to Halgavi during his asylum procedure, and whether his announcements being examined by the court before.
Your Excellency, he submitted the threatening letters from the Zuchians on the first set of the proceedings, and it was his first argumentation that he threatened in Neraria, and this was assessed by the court. But then he submitted additional argument that when Migration Service of Neraria submitted that he can be protected by the government in alternative, even if he is threatened. And Mr. Nasultiron answered that he cannot be protected because he is a former rebellion, and this was a new argument which was not answered by the court.
I'm just asking about the last sentence of paragraph 7, which was that Mr. Tiron has been asked about the threats while returning to the country of origin, but he avoided answering. It seems like he uncovered his threats after it was found that he was the former member of the Zuchians.
Your assessment by the Immigration Service of Neraria. I will pass the floor to my colleague Mr. Anton Makhno, and may it please the court.
Good morning, Madam President, Your Excellencies, esteemed opponents, may it please the court. My name is Anton Makhno, and I am deeply honored to appear before the European Court of Human Rights as an agent for the applicant, Mr. Nasultiron, in the present dispute. I will be speaking for 8 minutes, addressing the third issue, showing that Mr. Tiron's expulsion and return to Halgavi will constitute breach of Article 3 of ECHR. With the kind permission, applicant will proceed with the submission. Applicant submits that Mr. Tiron, if deported back to Halgavi, would face a real risk of being subjected to treatment contrary to Article 3. The decision by a state to expel a fugitive may give rise to an issue under Article 3, where substantial grounds have been shown for believing that the person, if deported, would face a real risk of being subjected to treatment contrary to this provision.
Counsel, who has the burden of proof to adduce sufficient evidence to demonstrate these substantial grounds?
Your Excellency, the burden of proof is on the applicant. However, according to the jurisprudence of this court, in the JK versus Sweden and the RC versus Sweden, the benefit of the doubt can actually shift to the to the applicant concerning the asylum proceedings. And Article 3 has an absolute character, as it enshrines one of the fundamental values of the democratic societies. And accounting for the HLR versus France, the court held that this provision may also apply to cases where the danger emanates from persons or group of persons who are not public officials. The ill treatment must attain a minimum level of severity to fall in within the scope of Article 3.
And how does that apply in the present case, counsel? In relation to non-state actors, will Mr. Tyrant be persecuted by non-state actors? Is that your submission?
Yes, Your Excellency, that Mr. Nasrullah was persecuted by the Zuchans, and upon his return to Kolgavi, he would be persecuted again. And
counsel, it seems like Mr. Kiran has amicable relationship with this party. He has consulted them before. His girlfriend published the post hashtag no new dance. So they are aligned with this party, it seems. So why would then you submit that he somehow is at the risk of persecution and treatment by this very group?
Your Excellency, this leads me to the first part of the submission, as the court, in examining the existence of such real risk, should assess the personal circumstances of the applicant and the general circumstances in the country. Your Excellency, regarding the post which the girlfriend of Mr. Nasrullah made, this resembles only her personal positions and her attitude towards the New Democrats and the social change. However, yes, the fundraising campaign was quite successful, but we cannot identify who was supporting Mr. Tiron. And
but it was held in Raja versus UK, for example, that applicant's personal situation should be worse than that of generality of other members of this group. How would you distinguish? Do you think this specifies here?
Yes, Your Excellency, this case indeed applies here, concerning the fact that, as the paragraph 9 of the present dispute provides, that Mr. Tiron submitted that rebels threatened and intimidated everyone who rejected to join them. When Mr. Tiron himself rejected to do so, he was beaten to near death, and as a result, he was in the hospital for 3 weeks. And accounting for the jurisprudence of this honorable court in the RG versus France, DNV versus Sweden, and RC versus Sweden, the past ill treatment provides a strong indication of a future real risk of a person being subjected to such treatment again. And as Mr. Tiron was beaten to near death, and this minimum level of severity was attained, accounting for Greece versus Belgium, where only 2 slaps were given to the individuals, and this constitutes ill treatment.
Do you have any proofs that he was ill-treated, even after staying in hospital for 3 weeks?
Your Excellency, as I stated before, the benefit of the doubt goes to the applicant in this proceedings, and in particular in the paragraph 10 of the present dispute.
Told that you should bring any proof before national court to show that past ill treatment?
Yes, Your Excellency. However, in the present dispute,
you hold that it has to be proved.
Yes, Your Excellency, it has to be proved, or it has to be recognized, as it was in the present dispute. The credibility of information provided by Mr. Tiron was not questioned, and moreover, the MSN extended the benefit of the doubt.
The credibility was not questioned in the first hearing before the national authority.
Yes, Your Excellency. However, this.
Maybe later.
Yes, this was later. However, the later decision, it holds that the fact was established that he was beaten actually, and therefore, as the government sources, they actually recognize that he was beaten. Therefore, it provides a strong indication of him being subjected to future real risk.
Counsel, it is great that you demonstrate that he was subjected to persecution in the past, but we are concerned here, what if he in the future will be at the risk of well-founded fear of persecution, and could you demonstrate why in the future could he be subjected to such a risk, especially taking into account that state now controls most of the territory? And yes.
Yes, Your Excellency. I would like to refer to the paragraph 11 of the present dispute. It states that Mr. Tiron has been receiving threatening letters from the rebels during his stay in the area. Therefore, it provides this court with the information that the threat to Mr. Tiron's life in Halgavi still exists. And in the matter of time, I'll proceed with the second part of the submission. Secondly, regarding the general situation in Khalgavi, while assessing it, the court heavily relies on the information contained in recent reports of independent international human rights protection associations, non-governmental organizations, international organizations, and governmental sources. Your Excellency, can I have 2 additional minutes?
2 minutes.
Thank you. Moving back to the present dispute, in January 2018, the United Nations Security Council expressed great concern regarding the situation in Khalgavi and condemned the violence committed by the government against the civilian population. In that particular case, in that particular issue, more than 350 people were killed and more than 2,000 people were arrested or went missing. And furthermore, in June 2018, the prosecutor of the International Criminal Court initiated an investigation for alleged crimes against humanity committed by the government. Yes, Your Firstly, according to paragraph 6 of the present case, little has changed during the reign of the new temporary government, and as a result, many Khalgavians continue to leave their homeland due to internal instability. And moreover, Mr. Tiron submitted that the new government failed to calm down insurgents, and the situation is destabilizing again. And furthermore, the rebels, they continue threatening and intimidating everyone who rejects to join them. And therefore, there are substantial grounds for believing that Mr. Tiron, if deported to Khalgavi, would face ill treatment. And for all the above-mentioned reasons, applicant respectfully asks this court to judge and declare that, firstly, the detention of Mr. Tiron by police of Naveria was unlawful. Secondly, that Naveria has violated Mr. Tiron's right to a fair trial. Thirdly, that Mr. Tiron's expulsion and return to Khalgavi will constitute breach of Article 3 of ECHR. And fourthly, that Mr. Tiron should be granted compensation for violation of his rights in Naveria, accounting for Article 41 of the ECHR. If I'm of no further assistance, thank you for your attention, and may it please the court.
Thank you, counsel, and we thank the applicant for submitting the arguments. Now it's time for respondents.
Dear Madam President, distinguished members of the court, I have a genuine honor to appear in this court. Thank you for your arguments. We respect your right to seek justice. It is the obligation of a state to prevent any act that poses a serious threat to national security where lives are at stake. Despite the fact this argument was delivered 17 years ago, it is still relevant. This message was delivered by Levan Alexidze on the 21st of September 2001 to the Orianda media. Juggling fundamental human rights is not accepted in any democratic society like Naveria. Today, together with my co-agents, Zelena Matias and Mark Goncharov, we will elaborate on the following claims. Firstly, I will address that the detention of Mr. Tiron didn't violate Article 5, paragraph 1c of the European Convention on Human Rights, as it was based on reasonable suspicion. The release was promptness, as well that the less severe measure was insufficient. Secondly, my co-agent Mark Goncharov will address that the present arguments do not constitute the violation of Article 6 of the European Convention of Human Rights, the right to a fair trial. Finally, my co-agent Zelena Matias will claim 2 arguments. Firstly, the compensation and the fact that Mr. Tiron didn't exhaust any domestic remedies in regard of compensation, as well as non-refoulement. The lawful detention of Mr. Tiron was based on reasonable suspicion. Deriving from Gusinski vs. Russia, paragraph 63, this should be a safeguard against arbitrary detention, and we recognize that. Naveria didn't target Mr. Tiron or discriminate him. From the very beginning, when he entered our state, we adhered to our domestic law and international obligations, because he entered with a forged passport. But with regard to Amos vs. France, paragraph 53, and UN Working Group on Detention, the asylum seekers who cross the border with forged passport may not be subject for penalties, as long as the Convention relating to the status of refugees in Article 15 provides. A reasonable suspicion implies that facts or information that should assure a reasonable observer that a suspect may have committed a crime. This was also examined and supported in Fox, Campbell and Huntley versus UK paragraph 32. Yes.
I have a question regarding Mr. Tyler's detention on 28 December 2018. And besides Mr. Tyler, other hundreds of people were detained. Were personal circumstances of all these hundreds of detainees examined before the decision was made to arrest them?
Honorable Justice, we may not make any new information to the case. We have no any surveillance data. However, we currently note that there is a precise number of detainees in asylum center, as justices put a notice, 100 of those detainees were in the asylum center. However, in this case, according to Article 34 of the European Convention on Human Rights, not an application of a group of individuals is examined. On the particular application of an individual, Mr. Tron is subject to examination, and each case was different. May I proceed, please? In a short period after Mr. Tyrol Nasrul was detained, he claimed that he wanted to see his lawyer. We are seeking justice here, that's why we mention all facts. Due to logistical problems in Nararia, as well as it was stated in RU versus Greece, there may be a derogation when there is a sharp flow of migratory flows, which also happened in Greece in 2012. That's why we trigger that derogation. Mr. Tron will
Also,
indeed...
but do you have a proof of comparability of the two situations?
Indeed, according to paragraph 6 of the case, the first 100 days of new government in Calgary were not successful. That's why there were many economic and social migrants coming abroad, as well as to Nararia. Thus, we had a big flow of migrations, and all of them should be respected, and we should assure the right to access a lawyer to each of them. Some of them were...
Was Mr. Tyrone an economic migrant?
Pardon, may you repeat this?
Was Mr. Tyrone an economic migrant in Nararia?
Indeed, Honourable Justice, this leads to my second argument. Mr. Tyrone claimed to be an economic migrant in his interview with the migration officer. However, during the case, he shifted from fact to the fact. There is a controversy here. Firstly, he claimed that he was once invited to be a member of the rebellion group, but he refused, and he was beaten after that. However, after he acknowledges that he actually was member of the rebellion group. So once he was invited to be a rebellion group, he refused, and then on his own he decided to be a member of rebellion group, and he on his own stated that he was reading prayers, as well driving from Article 8 of the case. His sister acknowledges that he was the administrator of the website Titlos, which made supportive arguments in favor of Mr. Tsushi, consequently Tsushians. Tsushians have Tsushians Executive Board, according to Amnesty International, which was recognized by this court in lieu to Economic Union Intelligence that states that Nararia had a high degree of corruption. The Amnesty International is frequently cited here, and Amnesty International said that Tsushians Executive Board has a direct link with Teneba. Consequently, Tyrone was admin in a platform of Tsushians. He had a direct link to Tsushians Executive Board, thus he had a direct link to Teneba. Yeah.
Turning again to Article 5, 1C, on what specific crime did your government arrest, detain the applicant, Mr. Tyrone? And do you know any jurisprudence of our courts concerning the threshold of specifying the crime in order to prove a reasonable suspicion?
Indeed, Your Honor.
Do you know, are you aware of any jurisprudence of this court?
Yes, indeed. For example, in Hartley Campbell versus United Kingdom, in paragraph 32, the Terrorist Act happened, and in our case, the order for the detention of Eastern Nasrul was based on the Nararian Terrorism Act, which was made with respect to Article 5, paragraph 1c. So the threshold in respect of terrorism with regard to Fox, Campbell and Hartley in UK is much higher than for ordinary crimes. That's why the threshold for, as well, reasonable suspicion is
higher than for ordinary crimes?
Yeah, indeed, it's higher than ordinary crimes. That's why we prove here that he misinterpreted many facts.
Counsel, but wasn't the violation of Article 5 found in this Fox, Campbell and Hartley versus UK case? And how would you distinguish this case from the present one?
In case of Fox Hartley versus UK, there was a surveillance information about the connection of the terrorism, and the source directly pointed that these people are connected to the terrorists. They did not disclose the source. However, they stated that the source directly pointed that these people have the link to terrorism, and the source described their characteristics. As I have already mentioned, Mr. Tron shifted from one argument to contrary argument. In the case Akhmatova and Bagurova versus Sweden, this court found that there should be a consistency of arguments. We acknowledge that according to guidelines assessing asylum seekers' claims, there may be shame, stigma, and personal circumstances. However,
what guidelines are those?
Those are guidelines for the countries when assessing asylum seekers' claims.
What is the legal
The United Nations High Commission for the Refugees.
Shall this court be basing its considerations on such type of a document? Is that a legal document, or what is the legal weight of that?
This is a recommendation, guidelines. However, since in a particular case we deal with a vulnerable person, asylum seeker, we should take that into account and acknowledge that there may have been shame, stigma, personal and contextual circumstances. However, in this case, we also had controversy between the arguments, which leads to the argument that we had a reasonable suspicion to think that maybe indeed he was involved in this terrorism act. Also, the last issue I would like to address is the promptness of detention. Mr. Taron, after he was detained, was also promptly released. He was detained on the 28th of December 2018, paragraph 15 on the case, and he was released after 2 days. The notion of...
was that for 48 hours? Less or more?
It was not stated in the case explicitly how many hours he spent there, and personally I may not interpret the facts. It just stated it's 2 days.
Do you think there may be a risk of violating human rights within those 2 days?
No, we state that the release was prompt. It derives from the French notion of aussitôt, which means that promptness has the connotation of immediacy and meaning as far as possible, and 2 days fall within the meaning as fast as possible.
And 2 days are as fast as possible for usual release of a person in relation to whom there is no intention to proceed with the criminal procedures. Is that what you suggest?
We are relying on 2 cases. The first one, Van Blink versus Netherlands, and the second, Broken versus the United Kingdom. In Broken versus the United Kingdom, it was recognized that there was a prompt detention when the person was released after 4 days. That's why we heavily rely on these cases, and by this conclusion, I indeed acknowledge honorable justices that no Article 5, paragraph 1c was violated by Nararia. I give floor to my colleague, Margot.
Counsel, just one question, if I may. Since you advocate for distinguishing terrorism for other ordinary crimes, is there any internationally adopted definition of terrorism, whether in the convention or jurisprudence? Are you familiar?
Yes, the United Nations Security Council resolutions in respect to terrorism terrorism according to the determination is given in paragraph 1. Letter F or G states that terrorists may also be group of not.
So does Security Council resolution equal convention? I think the question was about convention.
As for the convention, there is no one objective and full definition of terrorism.
Thank you.
Distinguished Madam President, Your Excellencies, my name is Mark Goncharov. I have an honor to represent the respondent, and I'm going to tell the Honorable Court that there was no violation of the Article 6 of the Convention of Human Rights. Right to fair trial guaranteed by the Article 6 of the Convention is a complex right that includes many aspects and procedural details that must be maintained. The notorious court system submitted in fairness, impartiality, and intention to act to the benefit of the individual, and we, as the protectors of the respondent, are going to prove that there was no violation of the Article 6 in civil level.
But Counsel, wouldn't you challenge the applicability of Article 6 in the first place?
Could you repeat your question, please?
Would you challenge whether Article 6 of the Convention is applicable in asylum proceedings?
We have not challenged, because our position is that the Article 6 is inapplicable in the asylum case. So going to the first issue, which is about an applicability of the Article 6, the applicant claims that the migrants are not protected by the any mechanism of the Council of Europe, which neither by the Article 6 nor by the Protocol number 7. So there is a reason for so it could be an issue for the court to create a new rule for the migration disputes, but our argument is that there is no reason to create new practice of the ECHR to adopt these cases to the migration, because Article 6 is inadmissible.
No, you do challenge that it is inapplicable. Yes?
Yes, Your Honor, we challenge it is inapplicable.
Oh, yeah.
It is. Of the protocol, it's inadmissible, not in the reason of applicability of the protocol number 7, but in the reason of the general rule for all the migration cases, which is, our argument is that first of all, the asylum procedures of Mr. Tiron cannot be identified as a civil dispute because he's a migrant. There were not only cases of Mayo versus France, already mentioned by the applicant, and Uzi and others versus the Republic of Moldova, based on the ground that procedural guarantees are already given by to refugees by the 7th Protocol of the Convention, but also numerous disputes from a case law where judges found another explanation. They offered the court to create this same rule that the decisions regarding to the entry, say interpretation of elements do not concern the determination of an applicant's civil rights and obligations or other criminal charge against him within the meaning of Article 6, paragraph 1.
Also, is asylum procedure presently stated a criminal procedure or a civil procedure?
The applicant tries to prove that, proves that it's a civil procedure, but our position that it does not knows this is neither civil procedure nor criminal.
So there is a lacuna. We cannot examine whether asylum proceedings were conducted fairly, or do you suppose there are any other remedies for the applicant? And how would you respond then to the applicant's submission concerning effective remedies?
Respondent used the case of Maui versus France, which is appeals to the Protocol number 7 of the Convention. Article 13 provided the guarantees of the national court system to the state, but our position is that Nararia have not violated the Article 13 because there were no any information in the case about this kind of violation. So only the the Article 6 were also not violated. Can I let the word to my colleague, Matjash?
Your Excellencies, my name is Rana Matjash and I will address the third and the first issue on behalf of respondent, namely that firstly, expulsion of Mr. Tiron would not constitute the violation of Article 3, and secondly, that no compensation should be granted to Mr. Tiron under Article 41. If it may please the Court, I will address these issues in turn. Honorable judges, respondent agrees with the fact that in order to establish the violation of Article 3, it is necessary to evaluate the real risk. However, respondent cannot accept the arguments of applicant that the circumstances in the territory of Calgary and that there is personal risk to Mr. Tiron that would prevent him from being expelled.
Counsel, has this notion of the real risk been interpreted in any of the judgments? What is meant by the real risk?
Yes, Your Excellency, this real risk was interpreted, and it was there were numerous cases. For example, Stern versus